crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with host David Lamb and the attorneys of Hollis, Wright.
Good evening and welcome in to the attorneys. Thank you so much for joining us this evening. Really interesting topic of conversation having to do with family law. And this is one of those shows that every time we discuss this topic, a lot of interest from our viewers. So if you know someone that may want to tune in tonight, you may want to give them a call and give them a heads up to join. It's going to be an interesting half hour. Ground rules for tonight. All throughout the show, you'll see at the bottom of the screen ways you can call, text, email, join our conversation. And don't forget, Hollis Wright makes available attorneys each and every Sunday evening for you. If you'd like to call them or text them, that number you also see there on the screen. That's a free, off-air, and confidential conversation. Some great legal advice is yours for the taking. So with that out of the way, let's get to the show. Leading our conversation, he's the managing partner of Hollis Wright. Josh Wright, good to see you, sir.
You too. Hope you had a great week.
Did well. Thank you.
We're spending a lot of time with family right now. That's been kind of commonplace during the COVID. But the reality is this is an area that our firm is not an expert in. And a lot of times what we're trying to do is give back to the community with a broad array of topics, not just stuff that we cover, but other things too. And so family law, we're going to be talking about custody-related issues, divorce-related issues, things that we get a lot of questions about. And when we do these shows, we bring on experts like we've got today in Laura Susan Burns. And first of all, welcome. You've been one of the longest-running guests on this show because you're so good in this area of the law.
No doubt.
Well, thank you. Thank you for that.
We're super happy to have you back on. And we have been spending a lot of time with family lately.
We have.
Have the number of your calls been increasing?
Absolutely. It is sort of a panic situation at this point. I've been behind closed doors. I've been in the same house with this person. I realize I've got to get out. So we have had a few of those lately, and it's pretty common.
Tell us a little bit about your firm and kind of what you guys specialize in. Let's talk about that just for a second.
Sure. Well, my firm is Burns, Brazier, and Johnson, and obviously I'm, like you, the managing partner of the firm, which is a lot of headache. But also, we are strictly domestic relations and family law practice. We leave it to the experts like you for our personal injury cases. We send those to folks like you, and we concentrate on divorce. We're mostly in domestic relations court, which is the divorce court.
So how did you get into this area of the law? Because I know this is not what everyone does when they come out of law school.
Right.
I mean, it's a unique specialty, and you got to be good at what you're doing with, I believe, a great temperament to do the type of work that you do.
The answer is by accident. I was working at an insurance defense firm many, many years ago and did a couple of domestic relations cases. And when you do domestic relations cases, you find out pretty quickly whether or not you have the patience and whether or not you have the talent for it. And it requires a lot of hand-holding, a lot of communication with your clients. It requires sympathy into some really personal issues. And in the end, you're handling the things that are most important to people, which most of the time are their children and their finances. So,
do you find yourself almost being a counselor at times? I know that your first response when someone calls is not always, hey, you need to go get a divorce. I mean, sometimes it's probably counseling to say, hey, look, you need to evaluate these issues and circumstances before you make this big decision. And I know there's got to be a lot of counseling that comes with that.
We do. In fact, in most of my consultations, which are in person, I ask people and encourage them, if they haven't tried counseling, to go ahead and give it a shot. Because in the end, even if you do end up divorced, you want to be able to say to your children, to your family, to your relatives, and to yourself, I gave it everything I had. I tried everything before I went down this path. And so we do encourage that for sure.
Yeah, it's a complicated area of the law. Like I said, it takes an interesting temperament to be able to manage clients and also help clients through a really tough time in their life.
We love getting questions from you all. The question we've got here, we're just going to jump right into it here since we've got you. My father started a business that I now own since my father's retirement. If I file for divorce, will I have to split my business with my wife who has worked there for years?
Well, the answer is it depends. In Alabama, the law as it is currently situated, is that marital assets are determined based on whether or not they were inherited in terms of whether or not those assets have been used for the common benefit of the marriage. And that determines whether or not that particular asset that may have been inherited is commingled. So in that situation, when you tell me the fact pattern that the wife has worked at the business during the course of the marriage, she may have an actual stake in the business, and it may be subject to a division. You have to hit the first prong in proving that the asset was used for the common benefit of the marriage and that she may have been involved in it and contributed to it. And then the second prong of that is typically in businesses you have to have a business valuation. You have to use Rule 26 to disclose an expert and have someone come in and value that business to determine what, if any, portion of that business would belong to the wife. So the answer is maybe.
How is property generally divided? Like, let's assume they don't have a business, but they have homes, cars, some resources and assets. I mean, how is Alabama a 50-50 state? I mean, how does it work?
Alabama is not a 50-50 state off the bat. Property, and I'll use your example of real property, like a beach house or a lake house, and then the marital home and those things, is typically divided by what portion of that was accumulated during the marriage and the equity that is contained therein. So that's sort of a fancy way to say, like, what did we build together, and that's what we're going to have. And that's generally how the law works. And those numbers are increased or diminished based on things like wrongdoing, based on things like contribution to those assets. The courts take into consideration a lot of factors to give what we call an equitable outcome, which is essentially a fair outcome.
How much of your role is negotiating what that fair outcome is with a prospective client?
It depends on opposing counsel. There are some people that you work with that are not interested in negotiating anything. There are some people that you work with that understand, based on experience, what the likely outcome would be, and you spend a lot of time in those cases negotiating, and often end up at mediation, which is a very valuable tool in domestic relations.
Yeah, so the mediation process, is it used to try and calm people down and try and find an equitable way where people can agree to properly divide their assets? And the second part of that question is, if mediation is used for that, do you find that the courts generally sign on to the agreement the parties have?
The answers are yes and yes.
Okay.
Mediation, like I said, is a valuable tool. And when you have an experienced and valued domestic relations attorney who is your mediator, they know what the likely outcome is going to be because they've stood in your shoes 100 times, 1,000,000 times. And so when that other lawyer, that third party, is able to tell your client or the other lawyer's client what the likely outcome is going to be, then obviously, you know, if it's kind of two heads are better than one, you've got two people saying the same thing, and people are inclined to listen. Another thing about mediation, in my experience, is a lot of times in a divorce situation, people feel like they need their day in court. And if the case ultimately settles, they may not have that day in court. And so a mediation is sort of an outlet where they feel like they can air some things and say some things and point some fingers, and probably a lot of times in the correct direction, but it is a way to sort of have that catharsis where it ends with an amicable settlement, but you've been able to sort of air your grievances.
You know, that's actually a great point that I'm going to use in my personal injury claims, because think about it. There are a lot of times when somebody says this is about principle,
right.
You know, it's not about money, it's about principle, and I want my day in court. And I've never thought of it that way, but mediation to a traditional client may look a lot like that opportunity for them to have that. I know we're getting ready to go to break. When we come back, I want to talk a little bit about child custody, because she can answer some questions and about how wrongdoing is managed in these divorces, how it impacts the division of property and those types of things. We need to talk about all that.
All right, we're stepping aside. As we do so, a reminder, Hollis Wright all over social media. Just search them out. Find them on YouTube, Twitter, Instagram, Facebook, all over the place. A great resource for you to keep up with what's going on and things that matter to you. Stay tuned. More of The Attorney is coming right up.
I'm Josh Wright with the law firm of Hollis, Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys.
Hollis Wright is a proud sponsor of high school athletics.
Contact the winning team of attorneys at Hollis Wright if you need help after an accident.
Our law firm proudly supports Alabama high school athletics as well as the AL.com Hollis Wright Player of the Week.
Be sure to go vote this week for your favorite player at the Hollis Wright AL.com fan poll.
Welcome back in to The Attorneys, talking about family law tonight. A really interesting conversation. Before we get back to this discussion with our panel of experts, a reminder, attorneys from Hollis Wright standing by live as we speak. That number you see scrolling at the bottom of your screen. Take advantage of that opportunity to get some free, off-air, confidential legal advice. Josh?
All right, so when we went to break, I mentioned I want to talk a little bit about child custody, and I want to talk about how child support is managed in Alabama, just generally, because that's not our main topic tonight, but talk just a little bit about child custody and how the courts manage that process.
So in recent years, the laws and the case law has really changed, and there is no maternal preference as there once was. There's no presumption that the mother is always the better parent or the parent who should have custody. During this day and age, both parents are presumed to be fit to have custody. And we are seeing a huge trend with the courts and with this area of law in that parents are sharing the children in the event of divorce. And, all of the studies and all of the psychological input we have from the experts tells us as lawyers that that's what's best for the children, that they have a schedule with the parents that's not necessarily disruptive, but gives them a good amount of time with both parents. And that's sort of where the law is going. That's where the trends are. And it turns out that's what's best for the kids. And so as a lawyer, we try to encourage that where it is feasible and necessary.
Where does wrongdoing in the marriage weigh into that? And does it? I mean, does it? Do the courts consider that?
I think it does. And I'll give you a couple of examples of that. So a lot of what we encounter in terms of wrongdoing is adultery, obviously. And so that really does weigh in, because if you're asking the court for custody of your child or your children, and the other party can prove that when you had opportunities to be with your children, when you had opportunities to spend time and money on your children, you were spending that time and money in an adulterous affair with a paramour, which is the legal term for the other person, then obviously it's going to weigh in, and the judges are people. They have common sense, and they understand that these things affect real life, not just the case itself. So I do believe that wrongdoing does weigh in on custody, and I think it should.
Real quickly, just broad issue here. I don't need you to get super detailed in this show, but on the issue of support. Generally, it's guided by a series of principles in our statutes. Right.
We have Rule 32, our statute, which governs child support. And the child support number is computed just by a couple of factors. The party's income, meaning the husband's income and the wife's income. And then also the cost of work-related child care cost. And in addition to that, the cost of health insurance for the children. And basically, you sort of feed all those numbers into a format, and it spits out a number. These days, because the forms are a little bit old and the numbers are a little bit low, a lot of our good judges are ordering, in addition to support, some sort of division of extracurricular activities and cost of the children in addition to that, to help with the cost of actually raising a child. I tell people all the time, child support's a bargain compared to what it costs to really raise a child.
Wow. Yes, I mean, you can see how not. Why do we bring her on the show?
That's the reason.
She knows all this stuff. That's all good information.
Speaking of child support, a couple of questions here about actions of an ex and seeking some advice. I'm just going to group them together, and you can take them however you want here. What can I do if my ex is not providing court-ordered child support and alimony? Question one. And the second question, my ex wants to relocate with our child who we share custody of. Can I stop her?
Okay. So we're talking about two different issues here. The first issue that you asked me about is a contempt issue. A court order is not a suggestion. It is an order. And judges can bind parties under the rules of 70A, which mean that they have the power that if you're not doing what that court order says in terms of taking care of your children financially or taking care of your ex-spouse financially, if you were ordered to do so, you can be put in jail. You can be incarcerated and held in civil and criminal contempt for not taking care of your obligations under a court order. So a lot of times with child support, when someone doesn't pay, it's sort of a pattern. They don't pay many times. And the numbers are computed. You know, we use Excel spreadsheets at my office, and then it's 7.5% post-judgment interest, which is a lot. And so the courts have the ability to not only ding somebody financially with a big judgment if they haven't been taking care of their court-ordered obligations, but they also have the ability to incarcerate if it gets to that point. And that's pretty tough. The second question you asked me about
related to moving, if the spouse wants to move, because we get that question a lot.
Yeah.
So Alabama is governed by the Relocation Act. And this is what I tell clients, and it's the kind of a common man's way to look at it. You can move wherever you want to, but the court is going to decide where those kids are. Yeah. If you guys both live in Jefferson County during the course of a divorce and you're able to share custody of your children, you know, if one party lives in, and I'm going to kind of go on the outer side of the county, if one party lives in Trussville and the kids are in school in Trussville, and then somebody decides to move to McCullough, which is the opposite end of the county, obviously delivering those children to school and things of that nature is going to be a problem. So you can object based on the custodial situation you have and the distance that it may be and the feasibility of taking your children to and from school, to and from activities. Right. And that's really important now that we're doing the joint custody. Obviously, there's a Relocation Act, which if a party moves more than 60 miles from their current resident, they have to notify in writing by certified mail of the move, et cetera. And then the other party has a right to object to that based on the children. And so it's based on the schedules of the children.
I know that there is someone sitting at home right now thinking the same question I'm thinking, and it's just the way my brain works. But is it possible for a child to attend two separate schools, or does the court, meaning let's assume they live in two different school districts, one lives in Homewood, one lives in Gardendale, or does the court desire to keep a child in a stable single environment with one school?
It's not possible because the school systems determine how many nights a child has to lay their head on a pillow in that school district in order to go to school there. So some of the most strict ones are some of the municipalities we have here in the Birmingham area. I know Mountain Brook has some very strict rules about whether or not both parents live in the city limits and how many nights, you know, the child spends with each parent. Some of those schools are a little bit looser in their requirements and only require half the time, and whichever way you divide it up, that's fine. But in the end, it's not really the courts you're going to have a problem with, it's going to be the school system. And so that's where practicality comes in. And these judges know. They know what the school systems are going to do. So they would never issue an order to put a child in two different schools because they know that the school system's not going to honor that.
You can see too, David, how the court is involved in all this stuff. I mean, their guiding principle is what's for the best benefit of this minor child or these minor children. And so having the court involved is also going to be real helpful.
Yep. Time for us to step aside. This is our final break of the evening. So if you want to join our conversation, just a few minutes remaining for you to do so. But stay tuned. More of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis, Wright. In court, attorneys are not allowed to tell juries certain things. For example, We cannot talk about a defendant's net worth, meaning the defendant's ability, resources, or insurance to pay a verdict. In this week's Legal 4-in-1, we're answering the question, why can't lawyers talk about a defendant's net worth to a jury? Now, Rule 403 of the Alabama Rules of Evidence states, in part, relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice. Long-standing Alabama cases have held that the net worth of a defendant falls under this catch-all rule and is to be excluded. The reasoning behind the rule is that if a jury knows a defendant is wealthy, then the jury might award more money to the plaintiff. And this goes one step further. If an attorney makes any remarks that suggest the defendant is responsible because he is wealthy or rich and the plaintiff is poor, that can be grounds for a new trial. If you're ever on a jury, the reality in our state is this. In almost every lawsuit that goes to trial, the attorneys representing both the plaintiff and the defendant have already looked at whether there's sufficient insurance coverage or assets to satisfy a verdict. Most likely, the parties would not pursue a civil lawsuit if damages could not be paid after a jury returns a verdict. So even though lawyers cannot mention the net worth of a defendant during trial, there likely are resources available to pay a verdict in court. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. And remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. And as always, thanks for watching The Attorneys right here on WDTN 13.
Welcome back into The Attorneys. Just 6 minutes remaining, so if you want to take advantage of the opportunity to speak with the attorneys from Hollis Wright, who are standing by live, the number there on your screen, take advantage of that opportunity. Josh?
Easy for you to say.
Clearly.
Easy for
I'm
you
a
to
pro.
say. That's it. So when I first started practicing law, the rules about how you do on-off with joint custody were totally different than I think they are now. What's an example of what you see with parents today when we have joint custody? Because it used to be like every Tuesday, every other weekend. How does it work now? Because I'm sure that it's changed.
It has changed in the last few years. And obviously, like I said earlier, parents are on even ground. So nowadays you see when you have a shared physical custodial situation, you see parents that are doing week on, week off. The children will be with one parent 1 week and the other parent the next week. That happens a lot. And that used to never happen. And also, you can get creative in the scheduling to give parents equal time. A lot of times we base that on work schedules. So people like all of us who have really intense weekly work schedules, maybe spending more weekend time with the parents. So we may do like a Thursday after school until Monday morning every other weekend, which is sort of an expansion on that standard for one parent. And then maybe on the off weeks, they would spend Tuesday night or Thursday night with that same parent. As long as the children have consistency and they're able to get used to what you're doing and thrive in that situation, you can be really creative in dividing the time equally. And a lot of times we see that. And we try to tailor those schedules around our clients.
How does college get managed in that environment? As I know there are lots of people that have divorce circumstances where children are really small or just born, but I'm sure there are a lot more that are closer to the college age, closer to junior high, high school. How does that manage and how's that handled by the courts?
Alabama used to have what we call post-minority support that covered college. That law, we called it Bayless, was abolished with a case called Christopher that came out a few years ago. So now judges do not have the jurisdiction to order post-minority support, meaning college. And it's just really up to the parents to pay for the college and to decide jointly and equally or however they want to do that. So Alabama is, in terms of custody and children, is out of the managing and ordering college education business.
Is that unique compared to other states?
Well, we were unique when we did have post-minority support.
Okay, gotcha.
Most states did not. So we kind of fell in line with every other state. in those terms, and and that if you're married, you have no judge that can sit there and tell you have to send your child to college.
Yeah.
So it's not really fair if
Yeah.
you're divorced to have the same.
This issue comes up a lot too, and that is retirement benefits. People have retirement accounts and pensions and whatnot. They get divorced. How are those managed in a divorce?
Those are managed in terms of the years of the marriage and whether or not you qualify to get a portion of your spouse's retirement. And it's done through a mechanism called a quadro, which is a qualified domestic relations order. And it's sent, that is a special order drafted after the final judgment of the divorce. And it divides pensions and retirement, 401k, all of that on a percentage basis. Okay. It's very unique to the provider for that plan or that administrator.
Well, another reason why you want to go, to a lawyer early to be able to assess, if you're thinking about divorce, the total impact it could have, because it could impact retirement, it's going to impact your children, it could impact, a lot of other things. Yeah. So it's something to consider.
We're just about out of time, a minute and a half remaining, but want to give both of you the opportunity for a final thought. And if you would, you go first, please.
Well, thank you guys for having me on the show again. I always enjoy it. I enjoy seeing you here and at football games and things like that for our kids. And I totally respect what you do, and I am so happy to have you to send people who are in need to your area of expertise, and I'm glad that you're there for that.
Well, then I'm going to put a mirror on you and say the same thing back to you. So, one of the things that has always been interesting about the show to me is that we don't try and be experts in things that we're not experts about. You didn't see me give a lot of information today, but I asked a lot of questions because I really do believe that we want to make sure that the viewing audience, those people out there that have these issues, go to the right people to be able to lead, guide, and direct them through really tough times in their life. And although I deal with a lot of individuals on the personal injury side who are at a tough time in their life, you deal with a lot of emotion and a lot of counseling and a lot of managing and juggling those things. That is very difficult as a lawyer. I know that is. And so you should be commended for the work that you do for people that need help from a child custody perspective, a divorce perspective, etc. It's super admirable, and it's a great part of our law, and I'm glad that we have people like you doing it. So you do a good job.
Thank you.
I mean
Thank you, and I feel the same way about you.
Well, thank you guys for being here. It was an interesting show.
Yep.
I think we delivered for the viewers, so thanks to both of you for being with us, and thank you, as always. We really appreciate you being here with us. We'll look for you next time right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.